My name is Jenn. I'm the director of the Strengthening Labor Standards Enforcement Program at the Workplace Justice Lab, which is based at Rutgers University. I'm a lawyer, and before joining Rutgers, I worked at the Seattle Office of Labor Standards, where I led enforcement there and helped launch that office. Now it's been a while ago. The reason retaliation is important to me, that all started for me when I was working for the city of Seattle and was investigating cases and overseeing other people's investigations of cases, and really saw firsthand the impacts of retaliation for workers and also how it impacted the work of enforcement agencies, right? When workers are too scared to come forward, when workers are too scared to participate in an investigation, it makes proving that other violations, like a minimum wage violation, has occurred really, really difficult. In my current position, retaliation is still really important. And so, one of the ways it comes up a lot is we do studies across the country that compare violations to complaints. And what we see is that in a number of low wage industries where there's high numbers of violations, there are relatively few complaints, right? And while there are a few different contributing factors to this, the main one is retaliation, right? Retaliation keeps workers from speaking up. It maintains workers in a place where they're suffering violations silently, right? And so, when you take a step back and look at retaliation and the way that it impacts workers across the board, you see retaliation really as an attack on the rule of law. And so without robust retaliation protections, protecting basic labor standard rights just becomes much more difficult. Workers have certain rights. They have the right to be paid the minimum wage. They have the right to speak up when they're not paid the minimum wage. They have the right to participate in an investigation. And so when those rights are violated, and when a worker is punished, right, for exercising a protected right, that's a really, really serious violation. And so retaliation is sort of notoriously difficult to measure, but there is one key national survey that was done a few years ago that found that 43% of workers who did speak up, right, who complained to their employer about a violation, was then retaliated against. The other important thing, right, is what retaliation does for workers, and it keeps them from speaking up. So the same survey asked workers, have you experienced a workplace violation, and did you speak up? And if not, why not, right? And 60% of those workers who had experienced a workplace violation said they did not speak up because of fear of retaliation. When you're looking at who is experiencing workplace violations across the board, we consistently find that women, immigrants, and BIPOC workers are experiencing violation rates disproportionately, right? So we see this a lot in our minimum wage studies. And the thing is, when you look at intersectionality, the disparities are even starker. There's one study that looked at retaliation under anti-discrimination laws and found that workers with the lowest institutional power, right, and these workers tend to be women, BIPOC, and immigrant workers, were the most likely to experience retaliation. Importantly, the study also found that the potential for retaliation increases as the power disparity widens between the target and the perpetrator, right? And the power relations between the perpetrator and the target of retaliation also greatly influence how the employer responds to reports of retaliation. So retaliation is really serving as a mechanism to maintain hierarchies within a workplace, right? So unsurprisingly, this study also found that retaliation is more likely to occur where there are high incidents of discrimination. So when you take a step back from all of that data, what we're seeing is that in exploitative industries, especially in low wage industries, which disproportionately employ immigrants, BIPOC workers, and women, there are violations of many workers' rights happening, right? So retaliation is one of a myriad of violations that workers who come from historically marginalized communities are experiencing. So we've recently seen Arizona, California, New Jersey, and Washington, D.C. pass some really strong retaliation protections as part of minimum wage or sick leave laws. We also see a lot of strong retaliation protections at the city level. And so what these laws are doing, most importantly, is creating what we call a rebuttable presumption of retaliation. So to explain it quickly, right, there are generally three factors that have to be proved in a retaliation case. One, that there was a protected activity. Two, that there was an adverse action. And three, that there's a causal connection between the adverse action and the protected activity. So if a worker complained about a minimum wage violation, that's a protected activity. They were terminated, that's an adverse action. And then the causal connection, the worker has to prove that the employer terminated them because they complained, right? So it's this causal connection that is generally the hardest to prove. And it's hard to prove for a number of reasons. One, the worker doesn't have evidence, right, generally about the employer employer's motives for taking adverse action to most states are at will, right? Employers can take adverse actions against employees for any reason or no reason at all. So what the rebuttable presumption of retaliation does is it creates a causal connection, right? It says that if an employer takes an adverse action against an employee soon after that employee has exercised a protected activity, then there's a presumption that arises that that adverse action was retaliatory. And then it flips the burden onto the employer, who must then prove that their action was done for legitimate, non-retaliatory reason. So taking that same example again, right? You have a worker who complains of a minimum wage violation. 3 weeks later, they're terminated. If there's a rebuttable presumption, it's triggered, and it flips the burden onto the employer to show that the termination was done for a reason that was not the minimum wage complaint, right? Perhaps the worker, didn't show up, showed up late as part of a broader pattern, right? But essentially, it's just flipping the burden onto the employer. So the employer has to prove that their action, which was done in close proximity, in close temporal proximity to the protected activity, was done for a legitimate reason. Those who claim to be pro-business will argue that that these protections are anti-business, right? More specifically, they will probably say that a rebuttable presumption of retaliation hampers employers' discretion to take appropriate disciplinary action when a worker has a real performance problem, right? But that's not the case, right? Like we talked about, a rebuttable presumption is just that, it's a presumption, right? It can be rebutted as long as the employer has appropriate proof, evidence, documentation, right, that any adverse action that was taken was done for a legitimate and non-retaliatory reason, right? So another example, right? You have a worker who says, listen, I'm not allowed to take my paid rest breaks, which, I'm due by law. 3 weeks later, that worker is terminated. It's really good public policy that an employer has a well-documented reason for terminating a worker so closely after, right, they have exercised this protected activity, after they've spoken up. So, and where this documentation exists, the employer will be able to rebut the presumption to disprove that the circumstances amounted to retaliation, right? So that's all this is. It's just switching the burden so that it's on the employer to prove, right, to document why they are taking an adverse action. What the rebuttable presumption serves as is sort of a proxy for the causal connection, right? So the causal connection is, why did the employer take the adverse action? What was the employer's motivation for taking the adverse action? And so it's really difficult for a worker to prove what the employer's motivation was, right? They may not have access to records. They may not have access to employer emails, right? Their manager may not be straightforward with them about it. And so sort of making a worker get into the mind of the employer, especially without access to certain documentation, it makes it really difficult to prove retaliation. And what the rebuttable presumption does, right? It doesn't exist in every case. It exists when there's temporal proximity, when the adverse action happens really close in time to the protected activity. And so what policymakers are saying is that, listen, we can presume that when the adverse action happened that close to the protected activity, there's a link here, right? There's a connection. And so we're not saying there definitely is a connection. We're saying that it looks like there could be a connection. And so given what we know, it's now the employer's burden, right, to show that any adverse action they took was for a legitimate, non-retaliatory reason. So it's not definitive. It's just saying, listen, you did this close in time. So now show us your documentation. Show us why you took that adverse action. And then with the appropriate evidence, they can prove that it wasn't retaliatory. There actually was a legitimate reason for the termination or other adverse action they took. So one thing, legislators can do to counter alleged pro-business arguments is, to potentially include some funding for business outreach and education about retaliation, right? So that businesses and also frontline managers, right, those people who are working every day one-on-one with workers, have the information and the resources they need, right, to fully understand the issue, to fully understand what retaliation is, and to fully understand how to comply, right, so that the employer is avoiding any circumstance where they may be under investigation for retaliation. Retaliation enforcement is substantively just very different from other types of labor standards enforcement, right? A minimum wage violation generally is a violation that's going to impact an entire class of workers. And there's going to be, usually records. You're going to have multiple workers who can testify about the hours they work, the wages they were paid. There's a lot of documentation. Retaliation is different, right? A lot of times it's this person's word against this person's word. And so there's a lot of credibility assessments. There may not be a lot of documentation. It's a different analysis. It's a different way of doing an investigation. And so, and a lot of retaliation laws are very weak, right? So what we hear a lot from advocates is like, listen, like this is what happened. How could the enforcement agency not find that this was retaliatory? That seems backwards, and it's had this much larger impact on other workers, that knew this worker that was retaliated against because they don't want to come forward, they don't want to cooperate in the investigation, they don't want to file a complaint, right? This chilling effect is real. So it's something that we hear about all the time. And it's also something, right, that advocates have been putting in ballot initiatives, right? They are trying to do something about it. So, I mentioned Arizona recently passed a minimum wage and paid sick leave law that included the rebuttable presumption of retaliation. That was done by ballot measure, right? That was done through a lot of advocate organizing on the ground. And then voters passed that law. It wasn't Arizona lawmakers, it was voters who enacted that law, which included these stronger retaliation protections. Recently in Florida, in the last 2 legislative sessions, advocates have also helped to get a law introduced that would include a rebuttable presumption of retaliation as well. It hasn't moved, right? But yeah, so advocates are definitely aware of the issue of retaliation, and more they're trying to figure out tools and strategies, right, and embed them in law that will actually, help deal with retaliation in a way that's more meaningful and actually does remedy the problem, right, for workers who are experiencing it. We have 2 papers on our website, the Workplace Justice Lab at Rutgers University. One is called Addressing and Preventing Retaliation and Immigration-Based Threats to Workers. Another one is called Essential Labor Standards Enforcement Powers. The second paper is more general. It talks about different enforcement powers that includes retaliation. So there's a section on retaliation that could be helpful. Another place to go is the National Employment Law Center. They have a great paper called Exposing Wage Theft Without Fear. States Must Protect Workers from Retaliation. I highly recommend that paper as well. Legislators should talk to workers, talk to worker advocates, right? Really listen and find out how widespread of a problem retaliation is in your jurisdiction, right? And how deeply it impacts workers and really just interferes with general enforcement, right? As part of that, also talk to your enforcement agencies, right? Get to know them and understand how they deal with retaliation. Make sure that the enforcement agency has the resources and the training that they need to, to appropriately and to effectively enforce retaliation protections. Really, it's all about education, right? What's the problem? Who's experiencing it? And then, here's a tool that you can use to address it.